This is Committable, and for this episode, we're talking about protection and advocacy organizations. And we're very fortunate to have here with us Gwen Orlowski from Disability Rights New Jersey. Gwen, you want to introduce yourself? Say whatever you want about who you are and the type of work you do.
Sure. Thanks so much, Jesse. So again, my name's Gwen Orlowski. I'm the executive director here at Disability Rights New Jersey. We're the designated protection and advocacy agency for the state of New Jersey. And I've been here since January of 2019. By way of my background, really quickly, I did not work in a protection and advocacy agency for my career. I am a public interest lawyer. I've been a member of the bar doing this work for over 35 years. Most of my career was spent in what people would think of as legal services entities, focusing on providing free legal representation to low-income people. But I've also done some work in state government and at the national level with the national organization, Justice and Aging. I'll say one more thing about my background in state government. I was with New Jersey's Department of the Public Advocate, which was dissolved back in 2010. And for a short period, for about a year, I was New Jersey's long-term care ombudsman. And I say that because as we talk about what a protection and advocacy is, there are some similarities between protection and advocacy organizations and long-term care ombudsmen under the Older Americans Act and legal services attorneys under Legal Services Corporation framework. So I kind of had those two pieces separately in my background that brought me to the P&A work.
So you're kind of looking at the similar work from a lot of different perspectives.
Yes. I actually think that background I had really brought a lot of richness to the P&A, especially as I grew to learn what it really meant to be a P&A in my first couple of years here. There was a little baptism by fire, right? Because I was here for about a year. I was doing some pretty significant changes in the organization to sort of amplify the work we did with our unique authority. And then COVID happened. So
Right.
that accelerated some of that because of the needs of people with disabilities during the pandemic. But I'm happy to talk about those, some of the work that we did more as this conversation goes on.
Awesome. I think a lot of people in the general public might not fully understand what a protection and advocacy organization is or like what that unique authority is. So very generally speaking, what is a protection and advocacy organization?
So that is an excellent question. And again, I'm going to draw on that unique background I have, which I think allows me to say that the Protection and Advocacy Authority is the most awesome authority out there, right, in the federal system that enables many of us to do this kind of work. And especially when you see the work that we do through a civil rights lens, right? It's so empowering of our ability to advocate for the civil rights on behalf of people with disabilities, because the statutory authority we have is just, like I like to call it, it's just awesome. It's just awesome. So let me kind of delve into that a little bit. And without going into a whole history of the protection and advocacy system, I do think it's important for people to know that we have our origins in some bad stuff that was happening in the early 70s. In particular, one situation at Willowbrook Developmental Center in New York came to the attention of Geraldo Rivera, who did a documentary, and that came to the attention of Congress. Congress is already looking at some of these issues, which led Congress to pass the first of the P&A statutes, the Developmental Disabilities Act, that focuses on people with intellectual and developmental disabilities. But thereafter, Congress enacted a series of legislation that touches on all people with disabilities at this point in time. So we don't have just one statute that gives us our authority. We have many, and they govern sometimes populations like people with mental illness. I'm using that term because that's the term in the statute. People with intellectual developmental disabilities, other disabilities, traumatic brain injury, and some talk about specific work. For example, our protection and advocacy voting work, or our protection and advocacy on behalf of Social Security beneficiaries to ensure that they can um, enter or stay in the workplace if they want to do that. So again, it's this framework of statutes that give us our authority. And that authority breaks down into, I would say, two main components with lots of other stuff that's really important as well. So the first component is our investigation and monitoring authority. So under this authority, we get to monitor any setting where a person with a disability is receiving services. We're boots on the ground. We can talk to people with disabilities, staff. We can take pictures. We can really go through that setting, any place that the person with the disability might be getting a service. So I like to say, maybe we can't go to the boiler room, but we can go to the cafeteria if they have one, or the living quarters, or the spaces where, for example, in a sheltered workshop where people are doing their piecemeal work. So we can go and monitor anywhere in that setting. And those settings are just really broad and have been affirmed under case law. So it's psychiatric hospitals, what we call developmental centers in New Jersey, intermediate care facilities, nursing homes, group homes, sheltered workshops, school, ICE facilities, youth justice detention centers, jails, prisons. I mean, the list just goes on. And we can monitor there. In addition, when we have probable cause to believe that there's abuse or neglect, and that can be because somebody reported it to us, could be an individual with a disability, a family member, a staff person, an anonymous. We saw it ourselves through monitoring, or it came to our attention another way, like a news article. Then we can conduct an investigation, and we can conduct that investigation of either individual allegations of abuse or neglect or systemic. And using that authority, we also get to access certain records, sometimes even without the consent of the person with the disability. We have to check off certain boxes. For example, they have to be incapable of giving consent. If they can give consent, we listen to the person with the disability. And the more serious and imminent the danger, the more our flexibility to access those records to prevent abuse and neglect. So that's sort of an overarching of our abuse and neglect authority. Can I give our investigation and monitoring authority? Can I give an example of?
Please.
So for individual allegations, we generally conduct what we call secondary investigations, which means that we are going to review all of the records and the investigation of the agency that is charged under state law for conducting that investigation. For example, the Department of Health in a nursing home, or the Department of Human Services in a group home for people with intellectual and developmental disabilities. And our response generally is to ensure that a thorough investigation is done by the entity charged to do it, and that appropriate actions are taken on the other side. I think this can be confusing to people because I think individual people frequently think that we're doing a primary investigation and that we have enforcement authority in our toolbox that we don't have, right? So we're not the police. We're not the licensing agency. We can't bring criminal charges. We can't pull an entity's license or limit admissions or somehow otherwise fine them or do some other licensing activity. So I think that can be confusing to folks. But I think that is nevertheless a really invaluable authority and investigation to undertake, because we can say to the entity that does have that authority, you dropped the ball. Here's what we found. This is what you need to do to make this situation right. So that's our individual cases. We also do a lot of systemic investigations. And I think that's where people see the fruits of our work more obviously, right? So I mentioned COVID before. One of the things that came out of COVID, COVID hit New Jersey hard and fast in the spring of 2020. And by April there were news articles on the front page of the New York Times about a nursing home in Sussex County. So as soon as we could, we went into that nursing home. It had been called Andover. It had changed its name to Woodlands. So we went in there in 2021. We started doing first monitoring, but it quickly turned into an investigation. The long-term care ombudsman also was in that facility. And together, we were there conducting primary investigations, right? Looking through client records, obviously with consent where we could get consent, making sure that people were safe from abuse and neglect. And the situation there was very serious, so serious that, we brought our findings to the attention of the Department of Health and the Department of Human Services. And ultimately, the Department of Health closed the nursing home down, right? We didn't have to use another tool in our toolbox, which I'm going to talk about in a second, litigation, because the Department of Health responded to the seriousness of the situation. And I think that that really was a combined effort of the P&A and the long-term care ombudsman. And we were really focused on people in that nursing home who had mental health disabilities. The third floor of the facility, we would say, felt to us like an unlicensed psychiatric hospital. And so people's needs weren't being met because they were people who had significant mental health needs, and they were in what I will call a plain vanilla nursing home, just not getting those services. And from that stemmed the abuse and neglect, and ultimately that facility was shut down. So that's an example of our systemic investigation authority. The next major authority we have is our legal advocacy authority, and that takes a couple of different forms. So we're a law firm embedded in Disability Rights New Jersey, and we do what people think of as lawyer work, right? Representing individual clients in legal cases that they might have, right? So we do that based upon our goals and objectives set each year with public input and board approval. So an example of that in recent years is when we were coming out of the unwinding of the public health emergency, and people whose Medicaid hadn't been renewed in 3 years were all facing renewals, and many of those people were terminated. We provided individual representation to every single client who came to us during that period of time. It was over 100 people. In every single case, we restored Medicaid, with the handful of a couple where the person actually wasn't eligible, right? But every other one, there was a mistake made, and we were able to rectify it and get people's Medicaid restored. And we did that in a traditional lawyer way. You're my client, there's a retainer agreement. We speak to the Medicaid agency on your behalf. We go to the fair hearing if a fair hearing is necessary, and we use the legal system to vindicate your right to be on Medicaid. So that's one of the things. We do those in a host of different areas. We also do systemic litigation. And when we do that systemic litigation, that could be through a class action. It could also be through our associational standing. And a good example of that is we have a lawsuit right now against the state of New Jersey regarding the conditions, abuse, neglect, as well as Olmstead issues under the Americans with Disabilities Act, issues related to letting people leave the facility when they no longer meet a commitment standard, against the state of New Jersey. And we do that as Disability Rights New Jersey versus the state of New Jersey. We stand in the shoes of people with disabilities in those 4 state psychiatric hospitals. And that lawsuit came out of another one of our systemic investigations that went on for about 2+ years, really looking at all the complaints we were getting from the patients in the hospitals, finding out about critical incident reports that were reported to us, viewing, videotapes, reviewing records, talking to people. And that culminated in this lawsuit where we helped vindicate rights through a systemic lawsuit. And after I say this last thing, I'll pause and see if you have any questions about all that. I've said a lot. Under our legal advocacy is also a lot of other work that we do that isn't litigation, like people think of lawyers with clients doing litigation. It's what I call policy with a small p and policy with a capital P work. So I'll do the policy with a capital P because people, I think, understand that better. So we don't lobby, we educate policymakers, and we do that by bringing to their attention the perspective of people with disabilities in legislation that is before the New Jersey legislator. That would be an example, right? So 2 years ago, there was a bill that doubled the amount of time for involuntary commitment from 72 to 144 hours. And recently, that bill was set to either be made permanent or then it was amended to extend it for an additional year. Well, part of our role on that is making sure that legislators really understand what the effects of this kind of legislation is for people with disabilities. So that would be an example of policy with a capital P under our legal advocacy. But we do a lot of what I call policy with a small p. And this is where we're working with these state agencies that have so much power over the lives of people with disabilities because they are the agencies that control and deliver the services that people rely on, that we can litigate against them, but we can also solve problems through open communication, ongoing dialogue, meeting with them regularly, bringing these problems to their attention and asking them to solve those problems, right? We all see this problem and we need you to solve it. And we could go through litigation, but we're going to win. So maybe you just want to do the right thing, right? So an example of that would be we had a really large scale investigation a couple of years ago into nursing homes where people with intellectual and developmental disabilities were living. And people with intellectual and developmental disabilities really shouldn't be in nursing homes under federal law, absent very specific circumstances. So part of what we did was look at that whole system, look at the people who were in those nursing homes. We went out to more than 70 nursing homes and interviewed, I can't remember how many people, I would say well more than 100, but maybe even more than 200. I can't remember off the top of my head. And in doing that, we saw a place where New Jersey really is not complying with the federal law as a cause of too many people going into nursing homes, as opposed to group homes or supportive apartments or other more community-based alternatives. So there, we didn't bring a lawsuit. We talked to the state agency about it and said, here's what it should look like. And we're at a point where they agree with us conceptually, and it's just a matter of making it happen. And that's Medicaid dollars, by the way, the problem. And as it's true with everything, when dollars are involved and money has to be spent, it takes longer. But I truly believe that we've changed their hearts and minds on this, and they want to get the federal law right now. And that came through our policy advocacy with a small p. So those are our two most important authorities, our investigation and monitoring and our legal advocacy. So I'll pause there because I've been talking for a while and see if you have any questions on any of that.
No, thank you for all of that. I think maybe those last three instances provide a great example because with the CEPP, I believe it's Conditional Extension Pending Placement.
Yeah.
That's a situation where there was a New Jersey state law, I believe in the 80s, that said that a person who has been cleared by a judge has said they've gone to a commitment hearing, they're being held at a facility, they've gone to a commitment hearing, the judge says, I think the criteria here is no longer being met, so this person should be released. And the state law says to the people in the facility, if you don't feel comfortable releasing this person right now because you don't feel comfortable with where they're going, you can keep them longer.
Mm-hmm.
And so I think it highlights maybe the importance of the protection and advocacy organization because you're talking about federal versus state. A state has passed this presumably in good faith. They believe that they are complying with whatever requirements they have. But if you look at the federal standards,
the Homestead is.
P&A, was Homestead.
Yeah.
So can you talk about that sort of navigation? So one question I would have would be about funding, because might be related to the PAMI grant, Protection and Advocacy for Individuals with Mental Illness. So you're receiving a specific grant, the P&A organization.
Yes.
And that specific grant has specific criteria or specific powers invested with that grant. This money can be spent for A, B, and C.
Right.
So when you see something like a state department or a state law that you think violates Olmstead or federal protections, how do you navigate how to approach that? because you have to then go to your grant and be like, well, what can we do? What can't we do?
So that's a really great question. And there are several different components to it. One is, I think you hit the nail on the head. All of this relies on our formula federal grants, right? We exist under federal law and are funded under federal law. And it's called a formula grant because it's not discretionary. Congress, authorizes it, determines if we're going to get more money or level money or less money, but it isn't discretionary. It's not competitive, right? We, by the very nature of being the designated protection and advocacy, we get the money. By the way, I should pause here. We were designated in 1994 by Governor Christie Todd Whitman. Before that, we existed in state government. And once designated, always designated, absent good cause. And that's really important because we're not a political football, right? We exist, and most P&As now are not located in state government anymore. I think 4 are in state government or in territory government. The rest are nonprofits. And that does, with the receipt of this federal money, which we have to use in accordance with what the feds tell us we have to do, but it does allow us to be not tethered to state money, which might unduly influence a decision to sue the state, right? So that's sort of been a bedrock, I think, of the P&As, though some P&As take state funding. We do not. There's a tiny little asterisk on that, but too complicated for this. So we have to use the funding for the population. So the money I mentioned before under the Developmental Disability and Assistance Act has to go to people with IDD, intellectual and developmental disabilities. The funding we get from, you mentioned PME, Protection and Advocacy for Individuals with Mental Illness, has to go for our work on behalf of people with mental health disabilities. And that grant also has a preference in the federal law for working on behalf of people in institutions. We can work on behalf of people with home and community-based settings, but our priority is on people who are experiencing abuse, neglect, or rights violations in institutions. And the example you gave of CEPP status, Conditional Extension Pending Placement status, is a perfect example of a rights-based violation that contradicts the federal law under the Americans with Disabilities Act, the ADA, and the Olmstead decision decided under the ADA. So there's a certain freedom by having that federal money to be able to do this critical civil rights work on behalf of people with disabilities, even when that conflicts with what's going on in the state. And I think New Jersey is a well-intentioned state, but it makes mistakes. It gets the federal law wrong to the detriment of people with disabilities. So that's a lot of power that we have. I want to talk about how we decide to use that power in a second, but before I do, it would be remiss if I didn't say our existence under federal law is at risk right now, right? And our funding is at risk. And so it's so valuable now to really help educate people about what a protection and advocacy agency is so that people understand the vital role we play in the system, right? And why it's necessary that we continue to exist and we continue to get the funding we need to do this work. But I want to go back to the other piece, what I heard, the other piece of your question. So how do we decide how we're going to use this awesome power? Because we have to be prudent, right? First of all, we're a limited resource. There's only a certain number of us. We've shrunk incredibly since January. We're about 42 people. We're about 33 now. We've lost 5 attorneys. So we have to be more mindful than ever on how we're using those resources. But we always, this is, my philosophy, and I'm very upfront with state agencies on this. Remember, I talked about policy with a small p? We'll do everything in our power to change their minds through rigorous legal analysis and advocacy about why they shouldn't be doing something a certain way and give them an opportunity to correct it before we're not trigger happy with litigation. And when we get to litigation, it's because we've done a thorough investigation. We have done significant amounts of policy advocacy with a small p to try and get them to change their policy, and that hasn't worked. And when that doesn't work, then a tool in our toolbox is litigation. So we don't go right to that, but once we get to it, we are incredibly thoroughly prepared to move forward with it. Hopefully we solve the problem before that, because that's really better for people. If we can solve the problem faster and sooner, litigation is protracted. It takes a long time. Like, that's a good thing. So it's always that with every issue. At any given time, I'm looking over because I have a whiteboard in my office, right? And ideas are kind of thrown up there a lot of times. So I can look over and see, at any given time, we've got a lot of stuff in the pipeline that could potentially be litigation at some point in time against the state of New Jersey or a particular department. But we're working it all the way along to try and make a change. I'll give a concrete example of that. New Jersey has what we call a cliff for private duty nursing when people turn 21. And this is really people with disabilities who are the most medically complex, because they need 24 hours a day of private duty nursing in order to prevent institutionalization. When you turn 21, by regulation, it goes down to 16 hours. We call it the cliff, right? You can no longer get 24/7, even if you've been getting it your whole life. And everybody agrees it's medically necessary. A family member has to step in for 8 hours a day to provide that private duty nursing. We think that's a clear violation of federal law, the ADA and Olmstead, which I mentioned already. We think it absolutely puts people at risk of institutionalization. And we think the New Jersey should change that because it's the right thing to do. And we've told them that ad nauseum. And we've been litigating that through fair hearings. And we're poised to do something at a more systemic level, whether that's going to the appellate division or going into federal court. We're poised to do something at the next level because it hasn't changed and doesn't affect a lot of people, but for the people it affects, it's really serious. So that's an example of how we think about and build into class action or associational standing litigation to try and make systemic change on things that the state of New Jersey is doing that's out of compliance with the federal law. And by the way, I mentioned the thing about people with IDD in nursing homes, and right now they say they're going to do the right thing under the federal law. It's part of the Medicaid Act. It's called the Pre-Admission Screening and Resident Review, the PASSR, which is so wonky. But if that doesn't get right, we're in a position to go in on that as well. And then the last thing I'll just say about that is we're also living in a time that when you're thinking about going into federal court, you really have to think about that, right? Because there are problems there right now, right? There's risk for going into federal court, even in the Third Circuit. So.
Yeah, two of the other examples that you provided, I think, provide an interesting complement for each other. One being going to nursing homes during COVID and trying to work with the long care ombudsman. Is that right?
Long-term care ombudsman, yeah.
And so in that sort of a situation, the sort of path of least resistance or the most effective path would be to acknowledge the state agencies or the state process that is supposed to be monitoring and fixing and try to get them to do their job. Is that right?
Correct.
Okay.
Yeah. So in that particular case, the Department of Health, both as the agents in the survey process from the Centers for Medicare and Medicaid Services, CMS got involved, as well as the Department of Health. And from the CMS point of view, it's that they can terminate their Medicaid certification, take away their payer source. And from the state licensing perspective, they could do a lot of things like limit admissions, but ultimately they could pull their license. And that's what they did. They pulled the license. I mean, they both took away their Medicaid certification and pulled the license. And that's a really effective way to get the result we were looking for. It didn't need litigation on our part, right?
Right.
Our presence there reporting back on a regular basis was enough. And by the way, the press, we used the press was very integral in that as well.
One of the big reasons why I wanted to start conversations about P&A system broadly, and then specific work that organizations are doing, is that a lot of the podcasting started because about 20 years ago, I went through involuntary hospitalizations, civil commitment, all in Massachusetts. But the end result of that was complete confusion about how anything works or what their laws are, because it seemed sort of erratically applied. One person said this, and then another person said this. And so after that, what my takeaway was never be detected, never be noticed by the system. When I traveled, I went to California, Georgia, New York, and everywhere I went was a new system. And I felt like now I've got to learn a new system and stay undetected by a new system. And so when I heard about the leaked potential budget cut from HHS, it was sort of frightening because this is for someone like me, like a P&A is kind of what we have in terms of keeping our state honest and in line. It's our best chance, kind of. And so I wanted to ask you if someone from HHS or from someone from the federal government were to ask you to explain why you should still continue to get this funding, what would you say?
That's a great question. I mean, I do think that the unique statutory authority we have allows us to do work on behalf of people with disabilities at both the individual level and the systemic level that touches on things that are like at the center of the meaning of people's lives, right? So, I mean, to be this basic, everybody wants to be free from abuse and neglect. And having an independent agency that is not the state licensing agency or otherwise state government is so essential, I think, for people to feel that they can be forthcoming, that they can share what their stories are, right? And not hopefully deal with reprisal. Not that we would ever, but I'm even thinking in our lawsuit, right? Our exemplars are anonymous so that they wouldn't experience retaliation. And then, the other component and a lot of the work that we're doing right now that's so essential for people with disabilities is ensuring that they can lead meaningful, inclusive lives in however they define community. And I know inclusivity is a bad word right now, but it is built into our statute from 1975. And I said, I refuse to be silenced on that word because we all want to live meaningful, fulfilled lives in the community of our choosing. And that's really what inclusion is about, right? It's that we have access to that community, that we're accepted by that community, that we have the things we need to live our fullest, best life in that community. And some people choose a nursing home as their community. I understand that that's a choice that some people make, and that is critically important too. But in that community, they have as much agency over their own lives as they possibly can have. And when we talk about those things, self-determination, agency, setting your own vision of what you want your best life to be, where you want it to be, those words are tethered to law. How do we do that? We do that through a society that has a rich network of civil rights laws that have a mechanism to enforce them. And that's why you need the P&A, right? As simple right now in a world where people rely on Medicaid to access home and community-based services every day, to get out of bed, to take a shower, to have the breakfast prepared and eaten, maybe to help them get to work, maybe help them while they're at work with tasks that because of their disability they need assistance with. That's rooted in law, right? And you need attorneys to help people enforce their right and access to those services. And so if you don't have a P&A, it's just naive, I think, to think that the legal network is going to pick that up. I mean, legal services will be there for some of it, but I think only the P&A has that total package and that expertise when it comes to people with disabilities to ensure that those two pieces can be met, that people are free from abuse and neglect, and that they have a mechanism to enforce the rights that are there so that they can design and choose and live their own best life wherever, in whatever community they want to live that in. So that's why I think we should continue to be funded. I have one other thing that I want to say, which is not totally on point there, but it's so essential, I think, to the conversation that we've had that I don't want to lose it. And I know we're coming up on time. We have a crisis going on in New Jersey around abuse and neglect in group homes funded by the Department of Human Services. There's been a series of newspaper articles about it, and some of the cases that are talked about there are cases that, that we were involved with. And I'll be honest, I think people think we dropped the ball, like we could have done more. And this goes, I think, to a question you asked before, like, how do we use our limited resources? And this also goes to why Congress should still fund us, right? Like, we are a limited resource and we don't have the bandwidth through our investigation and monitoring and our legal team to carry on both an in-depth investigation into 4 psychiatric hospitals and a major lawsuit. At the same time, we're investigating abuse and neglect in the hundreds of group homes throughout the state of New Jersey and coming up with a systemic response to that. I wish we could, right? I wish we had that breadth, and we don't. And so even as it stands right now, we have to pick and choose what we're going to work on at any given time, right? We might have to say we're going to do this now. Kind of was like with the nursing homes coming out of COVID. That was the hottest thing to touch. That's where we needed to be. We postponed our our psychiatric hospital investigation for a couple of months to finish out that nursing home, then do that. Now we have this other issue. And, I can't imagine a better statutory framework to set up to address abuse and neglect in the community. It really is a matter of resources. So, let's not constantly reinvent the wheel when we've really got something great to begin with. And B, let's talk about how we need to fund it properly so that all the work can be done, both work in the institutions around abuse and neglect and work in the community, which is a lot more resource intensive because it's dispersed and it's all over the state, to ensure that people who are living in the community are free from abuse and neglect as well.
Yeah, I know a lot of people like to focus on balancing a budget and talking about saving money through with the federal government, which I get. So if the human rights perspective and the advocating for basic human decency isn't a selling point for some people, I think what you're presenting is return on investment because you're talking about Medicaid fraud. You're talking about people being held in facilities, which is really expensive, people being held there longer than they need to be. So if you want a return on investment, this seems like the right way to go.
It was for people in the Attorney General's office to look at Woodland, the nursing home, to see if there was Medicaid fraud there. But at one point in time, I did some simple math, and I don't have it at the top of my head anymore, but like what I looked up the daily rate for that facility times the number of people on that 3rd floor, and they were bringing in well over $1 million a month in Medicaid dollars to that 3rd floor for those slightly less than 200 residents who were living there. And it was hard to see, to my eyes, how the taxpayer was getting their full value out of that 1.1 or $1.2 million that was being spent by taxpayers to support people on Medicaid on that floor. Like, I definitely think maybe it wasn't criminal, maybe it wasn't fraud. I'm not the one who does that. That's the AG's office. But I have no doubt to say that we were not getting value out of our Medicaid dollars there. We were not using them in a way that was providing meaningful supports to people with mental health disabilities to address their mental health needs and to give them the supports they needed to regain skills to live in the community and then move them back to the community, right? Which is always going to be less expensive than an institution. And what people want, right?
Gwen Orlowski, thank you so much for being here.
Well, thank you so much, Jesse. It was really a pleasure to speak to you. And thank you for bringing sort of what I see as sort of an educational P&A 101 to your listeners, because I think there's a lot of things that go on funded by the state government, by the federal government, that people just don't really understand, and they don't understand the importance and significance and how it makes a meaningful difference in people's lives. So just couldn't be better timing to talk to you about this issue.